both of the Dinsmore law firm. And a little background, Adrian and I actually are in leadership roles on the IPO licensing committee. That's how we met. And, considered him a friend, and we've done multiple presentations together and actually authored a paper together as well. So just another example of, joining some of these organizations. You can meet really great people and from all over the country, because Adrian's in California and Nicole's in Ohio. They're going to be presenting on negotiation ethics, principles, and practices in IP acquisitions, and I hope you all enjoy the presentation. I'll hand it over to Adrian.
Thanks so much, Chris. I appreciate your kind words. And Chris and Tim and Andrea, I really appreciate the invitation and the opportunity to present to this group today. This is a presentation that Nicole and I have given before, so we've done some interesting research, and it's a really interesting topic, and I hope that you find it interesting as well. I'm Adrian Cyhan, as Chris mentioned. I used to live and work in Michigan, so I feel a little bit of a kinship with everybody on the call. I was an automotive design engineer for several years before going to law school, and then made my way to San Diego via Chicago. So I'm very familiar with the Midwest, and definitely have a lot of ties there. And Nicole, if you want to go ahead and do a quick intro, and then we can dive into the presentation.
Absolutely. I'm Nicole. I live in Cincinnati. I'm a partner here at Dinsmore. And but before that, I went to law school at Michigan State. So I did live in East Lansing for a few years. And we have a couple offices in Michigan, so we try to keep close ties with the state and travel there often. Really looking forward to the presentation today.
And I'll just add real quick that Nicole and I are both members of the IP practice and work in technology transactions at Dinsmore. So we negotiate a lot of straight up IP licenses, university research agreements, collaborations, joint development agreements, and all those due diligence on corporate deals, all those types of things. Nicole, jump in if I forgot anything that you want to mention.
No, I think you hit it all.
All right. Well, with that, I'll try to share my screen here, and we can jump right into the presentation. Okay, so is the presentation showing?
You're good.
Yes.
Excellent, thanks. All right, so today's presentation is on negotiation ethics, principles, and practice. And we've got a lot of ground to cover and a lot of slides, so I'll try to keep moving through pretty quickly. The topics that we're gonna cover today are the business case for ethical negotiations, communications with third parties, confidentiality, truthfulness and fair dealing, and conflicts of interest when representing corporate family members. And just a word of notice to everybody, the presentation pretty much cites the ABA's model rules of professional conduct, unless we otherwise specifically indicate. And most states have adopted these model rules with some variations in some cases, but keep in mind to look up any differences in the states where you have an admission. And with that, I'll turn it over to Nicole for the business case for ethical negotiations. And if I fall behind, just let me know to advance the slide, Nicole.
Okay, you can go to the next one. Okay, so we're going to talk really briefly before we jump in about why ethical negotiations are important. I think for all of us on this call, the number one reason it's important is because not following these rules could potentially get you disbarred. So we want to make sure we're staying on the right side of the rules that apply. But on top of that, for your clients, when you conduct an ethical negotiation, it does a few things for them. It encourages repeat business. And it preserves their reputation. So if you're conducting an unethical negotiation and your client gets sued, that doesn't look so good. Another thing is it builds trust. Without trust, you likely can't get the deal across the finish line anyway. So it's really important to build that trust with the other side as you're negotiating. If you conduct an unethical negotiation, basically the opposite happens. You're signaling that you're a bad business partner on behalf of your client. You're reducing that trust. You could also encourage retaliation, which is just going to escalate things further. And in fact, some studies have shown that when you engage in deception, it actually harms the outcome for your side. And just so everybody's aware, the standard we're using in this presentation for ethical negotiations, because that is kind of a morass of people's values and philosophy, is just the ABA model rules. So as long as you're staying on the right side of those rules, we'll consider it an ethical negotiation. And then on top of that, different clients, different people have their own values that they ascribe to being ethical as well. Adrian, if you could advance the slide. So a couple things to be aware of. There are some situations, and this is reported by the Harvard Business School, that will lead to an unethical negotiation. So bigger stakes are going to cause people to act more unethically. They also become less prominent when you're negotiating with an organization or a group instead of a person. When a person's on the other end of the line, we tend to act a little bit more reasonably, a little bit more compassionately to the other person because you now have a personal connection. If you're the party with less power, that could also cause you to deprioritize ethics in the negotiation. And a lot of times too, I mean, we've all heard this from our clients. They have a time constraint. They want to close a deal by X date. They need to start the research by Y date. It's important for their business that they get the money paid out at a certain time. And all of that just puts unneeded pressure on how people act to try to get something across the finish line. So knowing these influences exist and when they can cause you to act or your client to act more unethically, it's just good to be aware, which is why we wanted to list them. Next slide, please, Adrian. And then, so the first topic we'll address is communicating with third parties. That's what we do as lawyers, right? We're always communicating on behalf of our client with the other side in a negotiation. The way that we are going to present these topics is we'll start with a hypothetical. We're going to do a lot of hypotheticals today because it doesn't really, one, it's boring to talk about the rules by themselves, but two, it doesn't really give you a sense of how it applies to your practice. So we'll start with a hypothetical, we'll then go through the rules, and then we'll end with a few more smaller hypotheticals that kind of call out those more common pitfalls or misunderstandings within the rules themselves. And if at any point in time, because we're going to be moving topic to topic, if anybody has any questions, just feel free to chime in. Always easier to deal with it while we're on that topic, but we'll try to reserve some time at the end as well. Adrian, do you want to advance, please? So here's our first hypothetical when we're communicating with a third party. So your client asks you to negotiate a supply agreement between your client and Acme. You know a little bit about Acme. They're a large company. You know they have a big in-house legal group. You've actually met one of their in-house attorneys, and you know that they regularly engage large law firms. So your client has asked you, please send this agreement to Susan. So you look Susan up and you know she's not an attorney. You can tell from LinkedIn that that is not her background. But your business contact at the client says that this deal has to be done by the end of the fiscal year and asks you to reach out right now. So you've got that pressure that we've talked about. Adrian, can you advance the next slide, please? So the first question that comes up, can you send that email? Can you reach out to Susan directly at Acme? And based on the facts that we have in front of us, you can. So because you have no actual knowledge that Acme is represented by counsel in that negotiation, you can reach out to Susan, even though she's not an attorney. And actually the Virginia Supreme Court issued an opinion earlier in 2020, in January, where they actually addressed a hypothetical very similar to this one because people were getting really confused about the rules applications. And there's really three key takeaways. For the rules to apply that prevent you from reaching out to somebody who's not represented by counsel, you have to have three things. You have to have actual knowledge that they are represented by counsel. You have to be communicating with the represented person about the substance of the deal, the subject of the representation. And you have to have done it in a way where you didn't have consent of that other person's attorney and you weren't otherwise authorized by law. So there's a lot going on here. And a lot of it depends on, obviously, the facts of what's going on. So let's go through a couple variations. Susan calls you out of the blue. She wants to discuss the agreement with you. She tells you, I don't want my counsel involved. They're just going to complicate things. So can you discuss the deal with her? Answer is no, because now you know that Acme has counsel. So, and they are representing Susan in that deal. So without Acme counsel's consent, which is one of the exceptions to the rules, you cannot talk to Susan about the deal. You can talk to her about anything else you want. Michigan football, doesn't matter, but you cannot talk to her about the deal without her lawyer present. Next hypothetical, please. So then Susan sends you a markup of the agreement. She's now copied a couple people, including Tim, who has an email address that you know is at an outside law firm, and Jill, who's an in-house attorney at Acme. She wants to have a call with you to discuss the red lines, but it's not clear that her counsel is joining. So now we've got that actual knowledge that we've talked about. You know that counsel is involved, and she wants to have a call, but you don't know that counsel is going to be there. So can you attend to the call? Answer is yes, but only if counsel's attending, or if you get counsel's consent to proceed without them. And this is a point that really trips up some of my clients. You know, I'll say, I can't attend that call if their counsel's not attending. And they'll tell me, well, the business contact at the other side said that they don't want their counsel to come. So it's okay if you come because their counsel doesn't want to come. And it's, you know, the other side doesn't care if you show up. And that's fine, except I need that attorney's consent and I need to see it in writing. So that's important. And it does make you the bad guy, and it kind of makes you feel like you're hampering things. But it's your bar number on the line. So you want to make sure you're doing it right. And usually people come around once you explain the reason behind it. And then the third one is, so Jill, the in-house attorney, she calls you directly. She doesn't include her outside counsel. So can you discuss the deal with her? The answer is yes. So the rule only is directed at non-lawyers. So if the person is a lawyer, they're fair game, even if that person has outside counsel, even if they're in-house and they have outside counsel. One CYA I do want to call your attention to, if you're unsure if somebody's represented by counsel, just ask. A lot of times when we send an agreement draft out to somebody and I know they're not a lawyer and I know we don't have any other lawyers copied on the chain, I'll always say, you know, let us know if counsel's involved, or just forward this on to your counsel and copy me so that I can discuss it with them directly. Because it is up to them whether they want to proceed without counsel, and in some cases that they will. Adrian, can you please advance the slide? And so let's talk about the rules that actually apply in these situations. So you've got ABA Model Rule 4.2. This one deals with people that are actually represented by counsel. So we've talked about kind of what's required by this rule. You have to know they're represented by counsel. You have to be talking with them about the subject of the representation. And if you're going to do it without their lawyer present, you either have to have their lawyer's consent, or you have to be authorized to do so by law or by court order, which is rare. So typically you're dealing with consent. And again, like we said, that consent has to come from the other party's attorney, not the party themselves. Can I have the next slide, please? So what if you're dealing with somebody who is not represented by counsel and you know they're not represented by counsel? Another rule in this instance applies. It's Rule 4.3. And in that case, if you know, you cannot misrepresent your role in the transaction. So you cannot let them think that you're their lawyer. You can't give them legal advice other than to tell them that they should go get their own counsel if they don't understand something. And this can be really uncomfortable. It can be really hard when the other party is asking you a question. And as lawyers, we all just want to explain complex legal topics, even when nobody asks us to do so. And so you're fighting this instinct that you have to be helpful, to explain your knowledge and things like that. So it can be uncomfortable, but you really do need to say, you know, I'm not your lawyer. I cannot explain this principle to you. You have to get your own counsel. You know, another good thing, practice tip here is when you're negotiating an agreement with an individual and you know they're not represented by counsel, or a company for that matter. I mean, oftentimes these arise in consulting agreements or agreements with small companies. A good thing to do is to include a clause in the agreement that says very plainly and clearly that this person understands that they understand the agreement they're signing and that they've had an opportunity to seek advice of counsel. It's not going to get you out of everything, but it is helpful, and it does kind of cause them to pay attention to the fact that they have now negotiated an agreement with another lawyer and they weren't represented themselves. Next slide, please. This next rule is kind of a no-brainer. This is the one, it applies to all third parties, whether they're represented or not. We have to be respectful of them. You know, you can't do anything that embarrasses them, delays or burdens them if there's no other purpose behind it. And you can't use any method to get evidence that violates their legal rights. The important thing in our practice that arises under this rule is if you get any document or information and you know that you shouldn't have gotten it, you know it's privileged, it's work product of the other attorney, it's legal advice, you're supposed to just delete it and notify the sender. This has happened to all of us, I think. You're copied by accident, or a business person forwards an email and lower down in the chain is a whole bunch of legal advice from their attorney. It's hard to ignore it. It's hard not to read it because you want to know, but that's not what you're supposed to do. You're supposed to delete it and then let them know that you received it and that you deleted it. Next slide, please, Adrian. So here's another kind of wrinkle. with third parties. So a lot of us think of our clients as a company and their employees as kind of all being one and the same, but that may not actually be the case. You might have situations that arise where an employee of your client is actually an adverse third party. Their interests are now so adverse to your own client that you cannot actually give them legal advice, and you have to tell them to go get their other counsel. In some cases, you have to actually get other counsel to represent the company if you found yourself now in a situation where you've given advice to both parties. So that's not cool. You want to avoid that. And then obviously you're required to report any allegations of misconduct. So if you know, or you should know, that interests are adverse, the interests of that employee are adverse to your client, you have to stop talking to them. I mean, you have to tell them, I'm not your lawyer, I'm the lawyer for the company, you need to get your own lawyer, because right now this is not, your interests are now potentially adverse to that company. Next slide, please, Adrian. So this is first hypothetical. In this one, you're negotiating an agreement between your client and a consultant who happens to be a professor at a university. Professor said, I don't want to spend money on legal counsel, I'm going to do this myself. Your contact at the client said, I know this professor, she was my advisor in my PhD program, and I want you to give her a quote unquote good deal. Okay, well, that's a problem because you don't represent that professor and you're not going to give her a good deal. You're going to do what's best for your client. So now that you know she's unrepresented, 4.3 and 4.4 are in play. So you've got a couple of things to do in best practice. Make sure that your own client and the professor know your role as counsel for the company. Include a clause in the agreement, just like we talked about, that the consultants had an opportunity to consult with counsel. And then also make sure that the only legal advice you give the professor is to get her own counsel if she doesn't understand what's going on. Another thing we do sometimes with universities, this is kind of unique to them because of a lot of the rules they have around use of their resources or their labs, is if you're really unsure of how the professor is acting, whether in their professional capacity as a professor for the university or as an individual, you can always ask the university to acknowledge the agreement in place, just to say that we know this is going on and we've gotten our consent. We usually include reps and warranties to that fact too, but those are all things to do that can protect your client as well. Next typo, please. So here's another hypothetical. You're contacted directly by a business representative of the other party in a negotiation that you're doing. She goes ahead, and because this last sticking point is indemnification, she emails you a memo that her company's counsel prepared, and she thinks it's going to help seal the deal. So what do? Well, if you know it was prepared by their company counsel and you know it wasn't meant for you, you have to notify the sender that it has been sent. In this case, I would consider notifying the company's counsel as well, since they drafted it. You have to either confirm that they've gotten the attorney's consent to provide the document, or if they haven't, then you need to go ahead and delete it. We'll talk about a couple things with this document. The heading says it's privileged. Inside it is details about the company's financial status, another litigation it is fighting, a general observation that they don't trust you or like you. All of this information you should not know because you should not have opened that memo unless you had consent to do so. So that's, again, this is a hard instinct to fight. Delete it, don't read it, let the people know that sent it on accident. Next slide, please. So here's the third hypothetical. This is going to address that wrinkle where you have an employee and a company. So you're called in, you're going to investigate a claim that company employees have bribed foreign officials in another country. So this is an internal matter, and they've asked you to come in and talk to some of their employees. You're interviewing Bob, the president, and he says that he may have given some money to a public official to keep things moving at customs. So now you have a problem, and Bob has a problem, because Bob's the one that has now bribed a public official at a foreign country. So you have to interview, during your interview with Bob, what should you be doing? Best practice. So be mindful that Bob's interest is now adverse to that of your client. So you can't really be representing Bob or giving him any legal advice. You need to make sure he understands your role in the transaction when you do interview him, that you are interviewing on behalf of the company and not interviewing him to help him. And you should also not provide him any legal advice other than just to go get his own counsel. This is a situation where familiarity and good working relationships can kind of cut both ways, especially if it's a really high-ranking employee at the company that you've worked with a lot. You have to make sure that they can start to trust you and think of you as their own counsel and not just counsel for the company. So you have to be polite, be firm, and really kind of fight that urge to help Bob out. All right, next topic, confidentiality. Okay, so we'll start with our hypo. In this case, this hypothetical actually comes, we've changed names, but hypothetical comes from a New York State Bar Association opinion that was issued back in January 2019. So some of the stuff in this hypothetical is specific to New York, but it's still kind of a helpful exercise. So you've got big box store company, they're gonna open a store in a rural area. Their in-house counsel, Larry, calls his friend Curly, who practices real estate law in that area, because Larry doesn't really know. He's not located in New York. They actually end up using a local broker, Mo. Mo finds that location. He facilitates the purchase of the land. And actually the custom in the locale where the lawyer is practicing is that the lawyer, rather than the broker, prepares the contract of sale. So Curly goes ahead, prepares that contract. It's a template he's used and honed over the years. He considers it, his best work. Mo, the broker, later learns from Larry that the contract was signed by big box store and the seller. So now Mo knows there's a contract. So he reaches out to big box store's local lawyer and asks for a copy of it. So the question then becomes, can Curly share that signed contract with Mo? Can Curly, the local attorney, share the contract with the broker? This falls under Rule 1.6, confidentiality, and actually the answer is no. That contract is the confidential information of big box stores. So Curly can't share it without getting big box stores' informed consent. Let's talk through some variations. Let's say that Curly knows that the big box store has submitted the signed contract with the SEC. So then can Curly share the contract? And the answer is actually, again, no. So they still need big box stores' consent. There is no exception under Rule 1.6 for publicly available information. This is kind of shocking to us as attorneys and a little contrary to how we all write NDAs and everything else, but it is still considered your client's confidential information, even if they plaster it all over the internet, press releases, etc. Another variation. So Curly doesn't actually want Mo to have the contract. Curly thinks this is a great contract that I've written and I don't want some broker to have it. So does Curly have to share Mo's request with big box store? Answer is yes. He cannot bury the request. There is another rule that says that a lawyer has to inform their client of a couple of things. One of them is any decision that requires their informed consent. So this is something that he cannot bury. He's going to have to go to big box store and say, your broker has requested this agreement. Can I share it? All right, next slide. So let's talk a little bit about the rules. Model Rule 1.6 basically just says you can't reveal any information that relates to the representation of a client unless there are certain circumstances that apply. There's a whole long list. We'll go through some in a minute. And we also have to take reasonable efforts to prevent inadvertent disclosure or unauthorized access to such information. A lot of your firms and workplaces do this already, but it's also on you to make sure that you're keeping paper files secure, not talking about things too loosely with other people, etc. So now for the next slide, we'll go to some of the exceptions. There's obviously a long list here. I think the slides will be accessible afterwards, so I'm not going to go through it, but I will go through a couple of things. Informed consent. For the definition of informed consent, you'll want to look at Rule 1.0. It is the agreement by a person after you've communicated all of the adequate information and you've explained all the material risks and any reasonably available alternatives. So it's not just saying, hey, can I share this information? It's, hey, can I share this information? This is the information I want to share. This is what might happen if I share it. And these are some of the alternatives you have available to you. So it is a longer conversation than just a, hey, can I have it? Another one I want to highlight because I think it's funny is the use of a client's confidential information to establish a claim or defense for the lawyer in a dispute with the client. The Texas State Bar actually had to weigh in on something because a lawyer had divulged client confidential information in response to a negative Yelp review. So to be clear, negative reviews online are not enough to trigger this exception. So I think what they're really talking about is a malpractice claim or something in court. So keep that in mind. Next slide, please. All right, we are into our hypotheticals now. This one actually was addressed by the South Carolina Supreme Court in June of 2019. Basically the premise is you've been invited to speak at a conference about a recent deal that you closed. You want to share certain details about the deal, so some of them are part of the public record. What do you do? So this is just another reminder that the obligation of confidentiality applies regardless of whether the information was revealed or contained in any court filings or generally known. The best practice is to obtain the necessary informed consent from the company, from your client. And another thing is, again, be careful of relying on press releases. There is no exception for publicly available or generally known information. And keep in mind too, that just because you sanitize or anonymize a story, that may still not be enough. You need to make sure that nobody can trace back who that story is about. Next hypothetical, please. So this one's getting more and more prominent as social media becomes the way a lot of us communicate. So you're going to go to a tech supplier's headquarters. You're going to negotiate a really high profile deal on behalf of your client who makes autonomous vehicles. So you decide you're going to share this. You're going to tweet it in the morning. Maybe it's geotagged, maybe it's not. But basically what it says is you're heading into an important negotiation today, very excited for the future of mobility with a car emoji. What's the best practice is obviously don't tweet this, just don't share it online. If you do share, be really careful of context clues, emojis, location settings, all of that can tip off where you are and who you're negotiating with. If it's important to share, get the necessary informed consent. But I don't know how that would go with your client. I really want to share with my personal Twitter followers about this deal. Do you mind? I have a feeling that they will say, please don't. And in reality, maybe a tweet like this is kind of innocuous and nobody can tell, and maybe it's not geotagged, but your client probably still won't like it. So it's best to err on the side of caution and not share it all. All right, and as for our last hypothetical, in this one, it's a little complicated, but essentially you're working as in-house counsel at a parent company. Parent company has this subsidiary that has been involved in really protracted litigation. It's expensive, it's burdensome. Parent company says, forget this, it's not improving, we're gonna sell the subsidiary. They sell it in part because of the drain from the litigation, but also because they wanna take the organization in a different direction. So there's a couple reasons here. There's a promising buyer and they ask you why the parent company wants to sell. So about this hypothetical that we're gonna go through is kind of the intersection between rules. So you've got this rule against sharing confidential information, right? And so best practice is you're not permitted to disclose any of the parent company's reasons for the sale. So you're gonna have to get their informed consent if that's what you wanna do. But here you have to be mindful of intersecting and even sometimes competing rules. So let's assume you're just not going to share with the buyer, but the buyer says, well, I can't find any cases filed against any of the subsidiaries. So I'm just assuming there's no litigation. You can't adopt that statement as true. It's not true. That's part of the truthfulness and fair dealing obligation that we all have. And Adrian's going to go over that next. If the buyer says that it assumes that it found the litigation and it assumes that it's manageable, that's another statement that you can't adopt as true. So you have to be, without divulging, that is a reason, or that the litigation is not manageable and it's a nightmare, you can't also make them think that you agree that it's manageable. So you are walking a line, and a lot of times it's okay to just say, I really can't get into this. You're going to have to talk to my client about that. If the business people want to discuss it, but I can't, I have some information that I've been privy to that I can't share. And hopefully people respect that. And that is the end of confidentiality. Are there any questions up to this point before I turn over to Adrian? Okay, awesome.
Thanks, Nicole. It's a great setup and a great way to dovetail into the next topic, which is truthfulness and fair dealing. And as has been our pattern so far, I will move to a scenario and talk about that a little bit first, just to give you a flavor about what's going on here. So a company called Seahorse Technologies won a government contract and has to develop a validated prototype drone submarine to the government by a certain date, or they'll be getting penalized for every day of delay. Laura, who's working as outside counsel for Seahorse in these negotiations, is negotiating a testing and facilities use agreement with Trevor who's an attorney with Barracuda Industries. So this is an autonomous submarine testing company that's building a brand new facility that will accommodate the Seahorse testing. Trevor is unaware of Seahorse's government contract and delivery obligations, and Trevor and his manager both stand to make significant bonuses for closing the Seahorse deal. So there's some pressure going on here. During negotiations to close the deal and secure advanced pre-contract funding for the facility, Trevor honestly tells Laura that the facility will be ready in plenty of time for Seahorse's anticipated testing. Don't worry about it. In the meantime, all the other open items have been resolved and the deal's ready to close. So fast forward to the future, 3 days before the parties are to sign an agreement and stage a joint press release, Trevor learns that a Barracuda equipment vendor who's been having financial difficulties has gone bankrupt and will not be able to provide a key piece of equipment that's needed for this facility, particularly for the Seahorse testing. Although there is an outside chance that a backup supplier will be able to provide the equipment in time. So question is it okay for Trevor and Barracuda to proceed with the contract and press release and just keep their fingers crossed that the backup supplier will come through? An alternative scenario is, what if Laura calls Trevor to check in about the status of the construction contract or the status of the construction before the agreement's signed, and asks Trevor point blank whether the facility will be ready? So in both of these scenarios, Barracuda's failure to have the facility ready on the promised date would be material to Seahorse, because it could cause Seahorse to incur liability for its failure to perform under its government contract. So failure to disclose, on the other hand, could be a misstatement by omission. And even beyond the rules of conduct, state tort law may require disclosure, or the entire enforceability of the deal may be disputed if the material facts are not disclosed. Taking this a little further with a variation, what if the equipment vendor has not yet filed for bankruptcy, but has reported dire financial difficulties to Barracuda under an obligation of confidentiality? In this case, it's another scenario of a tension between the rules. And so the thing that you've got to think about here as an attorney is to consider this in view of applicable rules of conduct that prohibit dishonesty, fraud, deceit, or misrepresentation, and assisting others to do so, and balance those against your obligation to not disclose confidences, such as the confidential information about Barracuda's situation. And so we don't have all the answers during this presentation, and there might not be a single answer to how to address this scenario, but some things to think about doing would be to have somebody on speed dial who is an ethics specialist or an expert on ethics, or a lot of companies have an ombudsman or some. The key thing is to have somebody that you might be able to talk this through and think about how the obligations and tension might weigh against each other and what's a good course of action. Ultimately, it might turn out to be something like a quiet withdrawal from the situation without disclosing any more confidential information or information that might be absolutely required. The relevant rule here is ABA Model Rule 4.1, which is truthfulness in statements to others. And so it deals with when you're representing a client, that an attorney shall not knowingly make a false statement of material fact or law to a third person. The attorney shall not knowingly fail to disclose a material fact when the disclosure is necessary to avoid assisting a criminal or fraudulent act, unless the disclosure is prohibited by Rule 1.6. So you can see we're heading into kind of a tangled morass of rules that have conflicting obligations. And that's just to underscore the point here that there is a tension between the lawyer's obligations of truthfulness to third parties, zealous representation of clients, and confidentiality. I'll also add that some commentators have really kind of been down on Rule 4.1. They're saying that, because of these strict qualifiers, knowingly and statements of material facts, I guess one perspective that commentators are taking are that is an attorney not obligated then to be truthful when it's not a statement of material fact. And we'll get into that a little bit later about puffing and negotiation tactics. So looking into these qualifiers more particularly, what does knowingly require? The ABA model rules say that actual knowledge of the fact in question, although knowledge may be inferred by the circumstances. Thus, an innocent representation, which is believed to be true and is later learned to be false, must be corrected by notifying the person who heard it, even if it's opposing counsel. in truthfulness and fair dealing, the focus is really on negotiations. And so, as I mentioned before, this pertains to statements of fact, although determining whether something's a statement of fact can be circumstance dependent. And so the generally accepted conventions of negotiation, and you've probably run into this if you negotiate agreements a lot, are that estimates of value, existence of undisclosed principal, and of course, avoiding criminal and tortious representation are all key things to think about when you are negotiating with somebody. You have to be, these can be issues of fact a lot of the time, and you have to be very careful about how you present them. And so the question comes up, what about exaggerations and puffery and misdirection? Because I think we've all been involved in negotiations where the other side was doing this. And so I'll talk about a little bit about an example in the coming slides about how to look at this. Then another issue here is, how do statements of opinion or statements about the speaker's state of mind differ? And so the ABA has weighed in on this and says that a party's negotiation goals or willingness to compromise, as well as statements that can be characterized as negotiation puffery, ordinarily are not considered to be false statements of material fact. And so what is a material fact then? It's one that may reasonably be viewed as important to a fair understanding of what's being given up and in return gained by the deal. And that's been determined. That's right out of a federal court case from Maryland. And also playing into this, what makes a fact material is one that could have influenced the hearer. So there's definitely some shadows of kind of the fraud elements here as well. Clearly, false statements of fact or law include overt lies and active misrepresentations. And as I alluded before a few slides ago, misrepresentations by omission. And ABA Model Rule 4.1 in comment 1 addresses this by saying that interestingly, there's no affirmative duty to inform an opposing party of relevant facts or to volunteer information. So you don't necessarily have to inform a party about settlement limits. However, you may be committing a misrepresentation by incorporating a statement of another person that is known to be false, or making true but misleading statements that are the equivalent of affirmative false statements. So I'll just sum up by saying that for the most part, however, there's no obligation to clear up misunderstandings, provided there's no active or intentional adoption or the promotion of a misrepresentation. I'll run through quickly some material facts versus puffery examples. So one, if you say we only have $4 million in insurance for this liability or claim, if $7 million actually exists, this would clearly be a misstatement of a material fact. If a party says granting you a license in the field of robotics will cost us a lot of money, that would be a misstatement of material fact if granting the license will actually have little cost to the licensor. The next three are all misstatements of material fact unless they're factually true. And so one thing to consider is be careful about using absolute terms, like words like all or none or things like that. It might be better to say mostly. You know, if you do have a stock contract that you're negotiating that it has terms that your client almost always gets, you know, a good way to talk about that would be to say, well, most of the time our client does this, or, you know, we always serve this up, and most parties, you know, do end up agreeing to this term. So I'll run through a hypothetical here. And so look at the scenario where a purchasing department is negotiating a supply agreement with a vendor and asks you as in-house counsel to help. And purchasing tells you privately that it will pay up to, but no more than $5 million for the contract. In your call with the vendor proposes $6.5 million, and you say, thinking that the parties will ultimately meet in the middle, right? We've all heard that, you know, aim high or aim low, and then you'll meet in the middle. You say we won't pay more than $3.5 million. The better practice or an alternative way to approach this might be to say, rather than we won't pay any more than 3.5 million, which would put you more on the side of it being a misstatement of material fact. A different way to approach this could be to say this deal appears to be worth $3.5 million, and then lay out some reasons why you came to that conclusion. For example, the logistical considerations, the competitive advantage we foresee, and anticipated warranty and return claims. That grounds it in more of a factual basis and doesn't actually rise to the level of making a misstatement of material fact. And it doesn't mislead the other side. So some takeaways to think about truthfulness and fair dealing are that unknowingly making a false statement of fact or a statement which is not material will not rise to the level of an ethical breach. However, an innocent misstatement must be corrected if its falsity later becomes clear. Exaggeration and puffery may be okay as long as no facts are misrepresented. And however, while some hyperbole may be expected in negotiations, do consider from a practical and from a relationship management perspective, is it worth potentially damaging the value of a deal and a future relationship, especially something that may be a relationship for a while? For as Warren Buffett once said, it takes 20 years to build a representation and only 5 minutes to ruin it. So we've got another topic to get through, but I see we're running up on our time pretty quickly. So I will try to get through the next slides and give some hypotheticals as quickly as possible. And this one has to do with conflicts and who the client is. Because as we recently, with globalization especially, businesses have increasingly far-flung business enterprises, and in-house lawyers serve dual roles often as counselors and business advisors. Now, the model rules focus primarily on counsel from law firms, and so there's kind of an imperfect alignment with in-house realities. I wanted to highlight that. However, Dem's the rules, as they say. So the ABA has even come out and said that an in-house legal department can qualify as a firm or law firm for purposes of the ethics rules, because if they are employed in a legal services organization or the legal department of a corporation or other organization. So that's important to keep in mind, that these rules don't just apply to outside lawyers, but there are ethical obligations, including with respect to conflicts as an in-house lawyer. Generally, as an in-house lawyer, there's no bar to providing services to a subsidiary, provided that the parents and the subsidiary's interests are aligned. However, these interests can start to diverge if and when there's a divestiture or a spinoff. So for example, especially if one of the parties is involved in litigation, but the other one isn't. Transactions between companies may raise diverging interests and insolvency. For example, if a subsidiary is undergoing insolvency, or a parent is undergoing insolvency, but the other party is not, that obviously raises some conflict issues. And so under Model Rule 1.7, the criteria for determining whether you can represent a client is if you reasonably believe that you can provide competent and diligent representation for each, it's not prohibited by law, and no assertion of a claim by one client against another who's represented by the same lawyer in the same litigation or other proceeding, and you have to get written consent from each involved party. And I think that's bringing us up to our time. So I will go back to Tim and Andrea and turn it back over. And I think that these slides will be posted, and our contact information is at the end of the presentation. So we'd be happy to, feel free to reach out to us if you have questions. Nicole and I would be happy to answer them. So that, I'll just say thank you for your attention. We're really happy to have been involved in giving this presentation, and look forward to hearing you and keep hearing from you and keeping in touch.
Thank you so much, Adrian and Nicole. Really appreciate it. And yeah, we'll make your materials available for download. So if anyone wants to review them, they can.
Thanks again, Adrian and Nicole. It was a great presentation.
Thanks, Chris, and have a great day, everybody.
All right, take care.
Here, everyone.
Well done. Thank you.
Thank you.
Thank you.
Thank you. Have a good one.